So I really tried very hard to come up with a longer name for this presentation, and I just couldn't come up with anything longer. So this is as good as it gets. I apologize. I don't have time in this hour for questions and answers. I think there's probably more information. We could go even longer. But I do want you to feel welcome to email me if you have a question about something that I mentioned. My email address is rharper@lionshr.com. I don't know how quickly I'll respond, but you're more than welcome to email me with any questions that you have. So let's get started. The EEOC COVID-19 guidance is addressed because of obviously the changes in the workplace that are a result of a pandemic. And if you aren't new to human resources, I'm going to assume that nobody here has any certain level of expertise or knowledge. And I'm going to, as much as I can, provide just base level information. So if you see EEO or EEOC, those are referring to the Equal Employment Opportunity Commission, which is the federal agency that enforces workplace and anti-discrimination laws. Those would be things such as the ADA, which is the Americans with Disabilities Act. Specifically, those rights that are protected by the EEOC or under their responsibility for enforcement would be things that protect the personal characteristics of an employee. Race, gender, national origin, ethnicity, those things you've probably heard a laundry list of them before. But it also includes disabilities under the Americans with Disabilities Act, which applies to private employers with 15 or more employees. The Rehabilitation Act also brings the ADA so that it applies to federal employees. You have the Age Discrimination in Employment Act, which is an age protection act for older employees. That's going to apply to employers, private employers with 20 or more employees. And then there's Title VII of the Civil Rights Act of 1964 that protects all of those characteristics that we mentioned earlier: age, sex, religion, and more recently that's been expanded to include gender identity and sexual preference. An addendum or a later amendment to Title VII was the Pregnancy Discrimination Act, which protects not only pregnant women, but women who are dealing with situations or conditions that are related to pregnancy, so it can carry on even after the birth of the child. The EEOC has given very specific regulation instructions to state that all of these laws will still apply during the pandemic, even though the workplace is very different now. There are things that we are all going to have to deal with that we haven't had to before. So new issues in the COVID-19 workplace. There are definitely new challenges, and especially if you're an essential business. Some people were able to send their employees home or do remote work. That may not be the case, especially in an assisted living facility. You have to ask yourself new questions though. For a candidate, is it safe to bring them in for an interview? You are obligated now to, more so than ever, to protect your employees from exposure, not only from your residents and visitors, even though they might be restricted, but even from each other. There are increased requests for accommodation that aren't based on a disability, but instead are related to COVID-19. There are leave requests for reasons that are not required by law to grant that leave request. You may be worried about high-risk employees. Can you make them stay home to keep them safe? Isn't that your obligation? Not really. And then now there are new reasons to harass and discriminate that have never been thought of before. You have employees who are working remotely that the other employees are jealous of and are creating drama and problems because of the different workforces, this new hybrid environment. You may be also dealing with scheduling issues. A lot of your employees who are parents have now become teachers. They became teachers in the spring when schools were closed, and virtual schooling became a common term in our homes. You have decreased capacity in the workplace if you have limitations as far as how many people can be in a certain place at a certain time. Are you creating an alternate day workforce to minimize the amount of people in the workplace? And then also you have employees who are caregivers, maybe for elderly parents or even a special needs child that need flexibility with their typical work schedule. And then to make everything even more exciting, the CARES Act and the FFCRA, the Families First Coronavirus Response Act, were both passed very quickly, and every employer was obligated, or that affected became obligated to stay compliant with those leave requests. And those were the regulations and instructions and guidelines for the FFCRA. For a while there was changing weekly. So it's all been a moving target, and I'm hoping that this presentation will at least give you some information on the way things are right now, with a little bit of help down the road. So the EEOC obviously knew that there were going to be changes in the workplace, and they wanted to provide employers some guidelines of how to deal with it. And they responded by giving just baseline information to all employers on how to deal with this. And there was a call out to employers to implement custom to your workplace, custom to your industry policies to lessen the risk of exposure to your employees. But you still have to stay compliant with EEOC laws. But remember, the EEO has said, wait a minute, our laws are not going to interfere. They're still current, but we want employers to be able to prepare their workplace to protect their employees. So they've issued guidelines to suggest that you still comply with the CDC, you still comply with the guidelines that have been put in place to best protect employees, keeping in mind that the EEO laws still apply. In March of 2009, or excuse me, in March of 2020, COVID-19 was declared a pandemic, and that changes everything in the workplace. And this is why. If you can remember back to 2009, the CDC issued an H1N1 preparedness guideline. It was called Pandemic Preparedness in the Workplace, and it was related to the H1N1 flu outbreak. So the EEOC has gone back and adopted that same preparedness guideline and just adapted it to COVID-19. And in fact, if you go online, they have taken the extra step of anything that has been added specific to COVID-19 is placed in bold letters so you can see, okay, what's different. But I'm hoping that this presentation will be able to help you know what is different and what is specific to COVID-19 that will help you. The purpose of adopting that 2009 publication and adding these new COVID-19 new regulations is to ease some of the restrictions on employers. And those eased restrictions, the purpose is to decrease the spread of COVID-19 and to limit exposure of employees as much as possible without violating their rights. So the way that I think you will get the most out of this presentation, given that we are in this virtual format, and keep in mind, I talk with my hands. When I give presentations, I usually walk all over the room. So I feel like I'm in a straitjacket right now. So I hope all of you will forgive me for moving around as much as I possibly can. But also, I think it will be helpful to you if when we go through all of these things, you think of someone or maybe a situation in your own office, your own practice, your own workplace that might be very similar, so that you can at least relate to a real life circumstance that I'm talking about. To understand what has changed, we need to look at ADA requirements and standards to know what's new now. The ADA protects applicants and employees, and it prohibits employers from segregating or classifying job applicants or employees on the basis of disability in a way that adversely affects the opportunities or the status of the applicant or the employee. It prohibits employers from participating in a contractual or other relationship, such as an agreement with a labor union or a referral agency, that discriminates against applicants or employees on the basis of a disability. The ADA prohibits employers from denying employment or job benefits to an individual because of the individual's association with someone with a disability. And then it prevents or prohibits employers from failing to provide a reasonable accommodation based on the known limitations of an individual with a disability, or denying employment to an applicant or employee because the applicant or employee requires a reasonable accommodation, provided that the accommodation does not pose an undue hardship on the operation of the business of the employer. And we'll go into that in a little bit more detail. Another thing to remember is that employers are prohibited from using employment tests or other selection standards that screen out individuals with a disability, unless the standard is job related and it's consistent with business necessity. So how has COVID-19 changed ADA accommodation requirements? Well, it's affected the restrictions on disability related inquiries and medical exams of employees and applicants. It changed the way that previously you couldn't exclude an employee from the workplace, and it's also affected reasonable accommodations all the way around. So, guidance is available from the CDC about the workplace that depends on the level of care, and that would include nursing homes, retirement communities, and even independent living facilities. And the CDC specifically addressed assisted living facilities, stating that vigilance with restrictions is a must for employees, and that in order to prevent the spread and to protect the residents of the facility. So these were the recommendations. Let me go back. Yes, okay. So the CDC specifically addressed assisted living facilities and gave these instructions. It recommended that employers be able to take quick action to identify, isolate, and test anybody possibly infected. Well, how are you going to know those things? It also suggested using contact tracing, testing those suspected of exposure, keeping employees informed of confirmed COVID cases among residents and other employees. Well, are you violating a confidentiality? Encouraging employees to immediately report possible COVID symptoms of themselves and others, sending employees home if they have symptoms, implementing flexible sick leave policies that aren't punitive in nature, and having a plan for employees who have worked when they may have been ill. Can you tell who that is? How do you know? So despite the eased restrictions and the guidance from the CDC, employers must be careful not to cross the line into seeking disability-related information. So if you see on the slide, the change that I'm going to talk about now, or the ease in restrictions, are specific to disability-related inquiries and medical exams. And although those restrictions are eased up, there's a slippery slope. An inquiry is disability related if it's likely to elicit information about a disability. Well, what does likely to elicit mean? In my opinion, it implies there's a consideration that there might be a disability before the question is even asked. That in and of itself could be a problem or an assumption. And then what qualifies for a medical exam is far-reaching. It doesn't have to be administered in a medical setting, It doesn't have to involve medical equipment or supplies. It doesn't have to involve interpretation of results by a medical professional, and it doesn't have to be invasive. So keep in mind, it's very easy to cross that line into non-compliance. So without a declared pandemic, we're going to talk about the way things were before you have issued a conditional offer of employment to a candidate. So keep in mind, what I'm telling you right now is before COVID. Before an offer of employment had been offered, disability-related inquiries and medical exams not allowed. There are prohibited questions, such as you can't ask about a disability, and you can't ask questions that might result in employees' disclosure of a disability. I'll give you an example. If you ask an employee about maybe daily medicines, you may end up finding out that the employee has diabetes. Well, diabetes is a disability under the ADA. So you have to be really careful about a question related to medicines that a candidate or an employee might be taking. You can't ask a candidate if they've ever filed for work comp. What prescription drugs do you take? Have you ever been treated for mental health problems? How many sick days did you take last year? Those things are off the table, but here are things that you could ask. Can you perform the duties of this job with or without an accommodation, a reasonable accommodation? Can you describe how you would perform a certain function? Suppose, and this is a real life example, we had a client who had a candidate that came in for a mover job for a moving company, and the candidate was missing his right hand. Well, obviously there's concern whether or not he would be able to move boxes when he's missing a hand. So it would be perfectly fine for that employer to ask the candidate, describe how you would lift a box. They don't have to identify the reason why they're asking, but they can ask for an explanation of how the job would be performed. You can ask a candidate, can you meet the attendance requirements of this job, and be very specific as to what they are. And then you can also ask the candidate if they have a required license to perform the job. For instance, if it's someone who's hired to be a driver and they're deaf, do they have a DOT waiver to be able to perform that job? Notice that the okay questions tend to be yes or no questions. They are designed to not elicit more information than is absolutely necessary. As far as medical exams go before the offer of employment, they are not allowed except for drug tests, illegal drug screenings. An employer doesn't even have to relate drug screening to the job itself. Illegal drug screening is perfectly fine. But now let's talk about after the conditional offer of employment, but before the new hire has started working. The questions and tests, the inquiries and exams must be required of all new hires in that same job category. In other words, the employee who is asked to show how he could lift a box can't be asked that after he's been given a job offer, unless everyone in that position is asked to lift a box to show how they would do it. And you cannot refuse to hire that person unless the reason is job related. Again, that's after the conditional job offer, but before they've started work. All information about applicants or employees that are obtained through disability-related inquiries or medical exams must be kept confidential. That means information regarding the medical condition or medical history of an employee must be collected and maintained on separate forms, in separate medical files, and must be treated as a confidential medical record. The storage of those records cannot be within a personnel file. I would recommend it not even be in the same drawer. They require a level of security that the typical personnel record would not require. So if you don't have a pandemic and you have an employee working for you, what disability-related inquiries can you make or medical exams can you require? During employment, they are prohibited unless it's related to the job and only if it's necessary to conduct your business. When an employer has a reasonable belief that it's related to the job or necessary to conduct business, then they may be allowed. The reasonable belief that an employee's medical condition will affect the employee's ability to perform an essential job function would be a relevant or an okay basis for those inquiries and exams. Or if the employee will pose a direct threat due to a medical condition. Now, I want you to pay attention to that very closely. The employee posing a direct threat due to a medical condition. That's very important to this entire presentation. There is an exception, and that is for an employer who can require an employee who's missed work to provide a doctor's note. An employer always has the right to ask an employee why they missed work. And so that's no different now. So what's different now? What has changed? It's the declared pandemic. So March 2020, everything changed when the World Health Organization and the CDC declared that COVID-19 is a pandemic. And that means the direct threat standard that I mentioned in my previous slide has been met. Typically, an employer who's asked about an employee's medical condition affecting the workplace or being a danger to that employer, even to others, you have to go through a fact-finding test to determine if that direct threat standard has been met. But the CDC and World Health Organization have answered that for you. It is a direct threat while a pandemic is declared. So what is a direct threat? It is a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by a reasonable accommodation. Assessments of whether an employee poses a direct threat in the workplace must be based on objective, factual information, not on subjective perceptions or irrational fears about a specific disability or disabilities. Keep in mind, the standard is already declared to be met. In the event that it's not met, there's no pandemic, then these are the things you need to consider. There are 4 factors. The duration of the risk that the employee poses a direct threat, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of the potential harm. Now, why am I going through this whole list of factors, which they're going to be on a slide for you in the future? If the pandemic has already said the direct threat has already been met. Well, as you know, the COVID-19 situation and health crisis is very fluid. It changes quite frequently. And hopefully, this COVID-19 pandemic or declaration of a pandemic will at some time be released. It won't be a pandemic anymore. And when that happens, the employer has to revert back to that fact-finding mission of determining whether or not a direct threat exists or the situation meets the standards. So how does a declared pandemic change things? Keep in mind that the goal of the direct threat standard is to protect employees and applicants and others. So after a conditional offer of employment, now you may screen an applicant for COVID-19 symptoms as long as you do it for all entering employees in the same type of job. And that applies regardless of whether the applicant has a disability. Medical exams are the same as they were before. Remember, any medical exams were permitted after an employer has made a conditional offer of employment, so that hasn't changed. But you can delay the start date for an applicant who has COVID-19 symptoms because the CDC has said that person shouldn't be in your workplace. And if an applicant is needed to start immediately, but the individual has COVID-19 symptoms, the job offer can be withdrawn, or you could postpone the start date because that individual cannot safely enter the workplace based on the CDC guidance. You cannot withdraw a job offer or postpone the start date if a post-offer medical exam reveals a medical condition that puts the applicant at high risk unless there is a direct threat. So remember, right now, we have a declared pandemic. That direct threat standard has been met. So that bullet point talking about when you cannot withdraw a job offer is only if the direct threat standard has not been met. An employer may require new entering employees to have a post-offer medical exam to check for COVID-19 symptoms if all employees in the same job category are required to undergo the same exam. Even if that's a new policy that you've instituted, that one employee that you're comparing it to, your historical employee population, it's okay if you have established a policy that moving forward, beginning with employee A, we're going to be screening everyone in this position using this same test. Suppose an employee leaves employment at a hotspot residential facility. The facility has been in the news because they've had so many positive cases. You have a new employee entering your workforce, leaving there. So just because that employee is more likely to have been exposed does not justify the test. That the test has to be done for every single entering employee in that same position. So what you need to do is be sure to follow the recommendations of the CDC or even public health authorities because they are not going to interfere with the ADA. If an individual with a disability poses a direct threat, despite reasonable accommodation, he or she is not protected by the non-discriminatory provisions of the ADA. What that means is if you have a high-risk employee and the direct threat standard has been met, even if that employee's condition is not something that is consistent with a reasonable accommodation solving the problem or solving the need, that's not going to protect that employee from through the ADA. So can you keep employees from the workplace? An employer can only prohibit an employee from the workplace if the employee, for health or safety reasons, if the employee poses a direct threat. Remember that standard is met right now. And below that, I show you the direct threat standard. So if the pandemic is lifted, that is the basis that you would use for determining if a certain employee poses a direct threat in the workplace. This is important because, as I mentioned a minute ago, there will be a time, hopefully, when the pandemic declaration is canceled and the direct threat standard is no longer met. And without that direct threat standard being met, you have to use this 4 criteria assessment. So in the absence of a direct threat, even though an employer may have the best of intentions for prohibiting a high-risk employee from the workplace, you want to protect the health of the employee, that violates the employee's rights. The same applies to a pregnant employee, and it applies to any adverse employment action with regard to a pregnant employee. So a reasonable accommodation, How do those work in light of COVID-19? Well, this is how they work outside of COVID-19. A reasonable accommodation can be required if an employee asks to be treated differently because of a disability. The ADA defines a disability as any life-altering condition. It could be diabetes, it could be that you need glasses. It could be that you might need a screen deflector because of an employee's vision issues. So anything that affects a major life function can be considered a disability under the ADA. The purpose of an accommodation is to create an environment where the employee can perform the essential duties of the job. If the essential job duties can't be done even with the accommodation, then that's not an accommodation because it's not helping the employee so that they can perform the essential duties of the job. And I'm sure you've heard the term undue hardship, especially with regard to a reasonable accommodation. Employers grasp and hold on to the undue hardship standard because sometimes it's about cost. When an accommodation results in a significant difficulty or expense for the employer, you have to take into account the nature and cost of the accommodation, the resources available to the employer, and the operation of the employer's business. If there is truly an undue hardship, the employer is not required to provide that accommodation, but still has to consider other accommodations that don't pose the undue hardship. But an undue hardship is not just about cost. That's what we think of first. It could be your staffing needs. Suppose an employee needs a flexible work schedule to attend therapy sessions, but that leaves you without a receptionist. Well, that's not that poses an undue hardship because you have no requirement to change another employee's schedule in order to provide an accommodation. It could be structural obstacles for the facility. I represented a franchise restaurant several years ago who had ADA claims filed against them because of their entrances. But to go in and fix the entrance to make it wheelchair accessible would have required tearing down the front of the building. Well, so there were too many structural prohibitions to be able to provide or update that building to provide a new type of entrance. Generally, the ADA requires employers to provide reasonable accommodations for known limitations of applicants and employees with disabilities. If you don't know, the employee comes to you and says, hey, I can't do my job because of this, and you're first learning about it, then you can absolutely do an investigation to find out what that employee is talking about. You get employee input. What's the problem? How's it affecting your job? You can actually ask for medical information from the employee's health care provider to get not only information about the disability and how it affects that job, but the ideas for reasonable accommodations. And the best way to do that is through a request form. Not only does that get you the information that you need, but it provides you the documentation that you need, that you have participated in what is known as an interactive process, which is extremely important when an employee requests a reasonable accommodation. It's a back and forth, fact-finding, input from the employee, input from the healthcare provider. And by the way, because of that request for an accommodation, the employer is able to obtain medical information about that employee that the employer otherwise would not be entitled to. You aren't necessarily entitled to a diagnosis, but you are certainly entitled to information from the healthcare provider to explain why the employee's condition is keeping them from being able to perform the essential duties of their job. So how can you protect your workplace under CDC regulations and suggestions without violating the ADA? Can you attempt to identify high-risk individuals? Well, before a pandemic, absolutely not. because there's no direct threat standard having been met. Remember that any health information that an employee provides you voluntarily still has to be treated as confidential, but it also gives you an opportunity to ask that employee if some type of assistance might be needed. And by the way, if the employee volunteers information, but isn't necessarily asking for assistance at the time, you don't have to give an immediate answer. Just having that knowledge that an assistance might be anticipated in the future is going to arm you with information that can help you be prepared and have your workplace ready in the event that assistance is requested. So what can you do to prepare the workplace without violating the ADA? You want to make sure your office, your facility is as ready as it can be, given the limitations that are posed because of employee availability, scheduling issues, and still trying to keep everybody safe. Before a pandemic, an employer can use employee surveys to gauge employee availability. You just can't ask disability-related questions. So you can't ask questions that are likely to lead to the disclosure of an existence of a disability. That's not allowed absent direct threat, but you can have voluntary disclosure. And an inquiry is not disability related if it is designed to identify potential non-medical reasons for an absence, even if it's during a pandemic or outside of a pandemic. You can ask questions about availability. You can ask questions that are not disability related or designed to identify potential non-medical reasons for absence during a pandemic. For instance, is public transportation available? Do you have a ride to work? And as long as those questions are put on equal footing as medical reasons. For instance, during a pandemic, you could ask, is there a chronic illness that would increase a risk of complications if you were to get COVID-19? If those are combined with the questions regarding non-medical reasons, then you're okay during a pandemic. But the inquiry should be structured so that the employee gives one answer of yes or no to the whole question without specifying the factors that apply to that employee. The answer doesn't have to be given anonymously, but it needs to be just the information that you need to be able to prepare the workplace. After a pandemic declaration, things change. You can send an employee home if they have COVID-19 symptoms. Why? Because employees should leave the workplace. The direct threat standard and the CDC have said that employee doesn't need to be there. Note that sending an employee home doesn't violate the ADA when there's a direct threat present or standard has been met, even outside of a pandemic declaration. You can ask an employee who calls in sick or isn't feeling well at work. May come to you, say, I don't feel good, or they've already called in sick. You can ask them questions about their symptoms to determine if they might have COVID. But be sure to limit your inquiry to symptoms identified by the CDC as related to COVID. And you know, those are ever changing. It used to be, do they have a temperature? Now we've learned not everybody who has COVID has a temperature. It used to be a cough, and the list has grown. So if an employee comes to you and says, I'm not feeling well, and you ask about their symptoms and they disclose one that's not related to COVID, then you can't send them home for being suspected of COVID. You can take an employee's temperature. Remember, the information from that test is subject to confidentiality. And you can take that temperature of the employee because the CDC and state and local health authorities have acknowledged that community spread is a huge issue and that this is a good precaution. If an employee returns from travel to specified locations by the CDC as hotspots, it's okay to ask questions about possible exposure that the employee may encounter while traveling to determine whether or not that employee should self-quarantine. or whether or not they can come to the workplace. And it doesn't matter if it was travel for work or pleasure. The CDC recommends that the employee stay home. If that recommendation is in accordance with the CDC guidelines at the time, then it's fine to send that employee home until it's clear that the employee doesn't have symptoms anymore. And another thing is that providing PPE or personal protective equipment can be an accommodation, can be a reasonable accommodation. Just as a side note, that could be something like providing non-latex gloves to an employee who's allergic to latex, or even using certain cleaning supplies as opposed to others that might have a stronger or very negative effect on someone with asthma. So PPE can certainly be an accommodation. So what else can you do? What about an employee who is asymptomatic? Well, you can make disability-related inquiries or require medical exams to identify high-risk employees if the direct standard has been met. Right now, it has because of the pandemic declaration, but that won't always be the case. We can hope. You can encourage employees to work remotely as a reasonable accommodation under the ADA if remote work is available. The employer can require employees to adopt additional infection control practices, such as requiring every 2 hours that the employee wipe down their desk with disinfecting wipes. I've got clients who actually have set an alarm so that every 2 hours an alarm goes off, the employees know, okay, it's time to clean. You can require PPE. Rather than it being an accommodation that is an option for the employer, you could require it. And that might be a face shield or gloves again. Keep in mind, a face covering is not PPE. A face covering is intended to protect others, not the employee. So PPE is intended to protect the employee. So face covering is not considered PPE by OSHA. So what if an employee comes to work and they get sick while they're there? What can you ask of that employee regarding that illness? During a pandemic, you can ask if they're experiencing flu-like symptoms. Now, that's the pandemic of 2009, H1N1 flu. So for comparison purposes, during H1N1, you could ask employees if they're experiencing flu-like symptoms. Well, now remember that preparedness document that has been adopted by the EEOC has now been updated so that you can ask employees who report feeling ill, either at work or even calling in sick, if they have symptoms consistent with COVID. So that's just an example of how that 2009 document has been updated. So the best practices for requests when you receive a request for a reasonable accommodation. The EEOC has acknowledged that COVID-19 has wreaked havoc in the workplace and will likely result in increased requests for accommodations, some disability related, some not. So typically employers have the responsibility to address those requests as soon as possible, but during these times, there are delays to be expected, especially if it's one that involves or means that you need information from the employee's healthcare provider. You all know anybody in the healthcare field or industry is severely strained right now. So being able to get that interactive process going with the healthcare professional may be delayed. Employers are encouraged to use interim solutions until that interactive process has been completed. And the interactive process is intended to determine what reasonable accommodation, if any, can be provided. Some that are considered reasonable are flexible work arrangements, different schedules, newly implemented leave policies that are not necessarily federally or state mandated, and then remote work arrangements when available. Obviously, healthcare professionals usually can't work from home, so that may not be a reasonable accommodation. You should provide all employees with information as to the process for requesting an accommodation related to disability. That might be a notice that's sent out to everyone, or even an updated policy that employees have to look at. That would include a list of CDC medical conditions that place certain individuals at higher risk of serious illness if they contract COVID-19. So it's a blanket information sheet, but it can also help certain employees know that because of their condition, they might be more likely to need a reasonable accommodation. And then the employer should identify the contact information for whoever an employee should get in touch with to direct their request for an accommodation. And keep in mind that could be multiple different contact persons. It could be based on the nature of the accommodation. If you have an accommodation request that's because of the employee's child virtually schooling, that's going to be very different from an accommodation request because the employee is a high risk for serious illness. So you may identify different people within your organization who have more expertise in one area or the other. And you want to ensure that the company representative is well trained on dealing with employees in a non-discriminatory manner, and that they know that the word accommodation is not necessary to officially request an accommodation. It can be an employee just saying, you know what, I can't do my job right now because of X, or this blank condition, whatever situation, is prohibiting me from doing this essential function of my job. And just that conversation in itself justifies the interactive process being created or started to determine what is a reasonable accommodation for that employee. And then you also want to let the employees know that the company is willing to consider any requests from employees who have those listed medical conditions, as well as any other medical condition, on an individual basis. In other words, it's not people lumped into a group, that it would be a one-on-one employee situation where that employee is dealt with individually, specific to their situation. So there's optional tactics that you can take here to be compliant and to be a little proactive. You could just go out and make a general inquiry to all employees to find out who would consider, or to let them know that you would consider requests outside of even a disability request or a request based on a disability. You could just let all your employees know, by the way, we understand COVID-19 is presenting all kinds of problems and differences and challenges for all of us. If you have a request for some flexibility on our part for your employment, please come let us know. Now, that might be inviting a herd to your door, but that's also showing that your organization is proactive in this COVID-19 situation. But then the other option, of course, is just to wait until you receive that request. And remember, it does not have to have the word accommodation out of the employee's mouth or even in a written document. So what do you do when you've received the request? Well, remember the goal is finding a reasonable accommodation that allows the employee to perform the essential functions of the job. And I know you're probably thinking, well, what about the non-essential functions of the job? The ADA has identified an expectation that when you provide an accommodation to an employee, that those non-essential functions can be assigned to other employees. So be very careful in your job descriptions of identifying what is considered an essential function for that position. Again, that reasonable accommodation is not one that would pose an undue hardship on your business or your operations. So you have to determine if the accommodation request is based on a protected basis for the accommodation, such as a disability or even pregnancy, or is the disability covered under the ADA? It's a very broad definition under the ADA. Are there applicable state and local laws? In Alabama, we don't have a mini ADA, but some states do, some localities do. So if you're operating outside of Alabama, then you're going to need to check to find out what laws are you having to stay in compliance with specific to your state and locality. And then you have to engage in the interactive process with the employee, which means you might be also reaching out to the employee's healthcare provider. If you don't have an ADA accommodation request form, I strongly encourage you to get one or develop one. I have a template I would be more than happy to share with you. If you don't have one, though, it's really important to document the process. If you look at accommodation litigation, the interactive process is always scrutinized very closely. And so as long as you, as the employer, can support, document, and show that you have been involved in that interactive process, you're going to be in a much better position than you would otherwise. So document the process, document the time, the date of all conversations, the content of the conversation, who was there, what was said, where and when it was said. An employee is not entitled to accommodation under the ADA to avoid exposing a high-risk family member to COVID-19. Keep that in mind. I've run into that recently when you have employees who care for elderly parents or other individuals who have a medical condition that puts them at higher risk. The employee is leery of maybe going and taking them dinner in the evening because they've been in the workplace. The ADA does not require an accommodation in that situation. An employer is not required under the ADA to provide an accommodation to an employee without a disability based on the disability-related needs of a family member. Very similar to that first one. And then most state and local laws prohibit discrimination based on familial or caregiver status, but they don't require an accommodation. So if you are dealing in another state, a different locality, then that might be something you want to check with. I would just say, don't forget that the EEOC has encouraged employers to be flexible. So although you may not be required by the ADA to provide an accommodation, if you end up with a discrimination or a harassment claim, being able to show that you were very flexible with employee requests is very important. So I know I'm getting really close to the end of this presentation, and there's just a ton of information that I want to share with you and just don't have the time to do it. But I guess probably what I would want to share with you more than anything is the requests that are specific to COVID-19. So if you look at this next screen, next slide is talking about the screening of employees. If they don't like the way they're being given a health screen, for instance, they may be asked that it be done a different way, and that can certainly be accommodated if it's a reasonable accommodation. Also, if there's an easy and inexpensive way to do it differently, then absolutely do it. It's just better in the long run. And then if it's not inexpensive or easy, then you can certainly ask for medical documentation to support the reason for that employee's request. Is telework a reasonable accommodation? This has been a question for years and years and years, and typically there's not a requirement that remote work be provided as an accommodation. You can do it if it's available, but I would imagine if you're working at an assisted living facility, there's high chance that remote work is not available. So just be sure if you have that request that you treat employees consistently with respect to those requests, and check whether there is an obligation under state or local law. Right now, even governor's orders and agency guidelines are going to be very critical for compliance questions. If remote work is not an option, it's simply not an option, and that's got to be because of the job itself won't allow it. And this will explain that a little bit more. If the job can only be performed at a work site, but the employee is high risk, then you will have to determine what actions can be taken, and hopefully it's on a temporary basis. You may be able to make adjustments to that employee's work, such as that would reduce contact with others, give them a modified work schedule, or even maybe temporarily transfer them to another position. Keep in mind, it's not required, but that flexibility on the part of the organization is going to be important. Accommodations for not covered disabilities, they're coming fast and furious. You've got virtual schooling, you've got FFCRA leave, you've got FMLA, you've got executive orders that send people home. So I would say be flexible. When I first took this job a few years ago, one of my bosses gave me this little gadget here because I'm vice president of human resources, and it just, I don't know if you can hear this, but it says, no! So whenever anybody asks anything, you just tell them, and but now I told him I needed a new one that says maybe, because COVID has changed everything. So you can't just go with no. You may have to try a different response. FFCRA, I'm not even going to go into that. I mean, that has been a nightmare. It's been great for employees. It's great for employers that can keep their people working, but it has changed so rapidly and it was enacted so quickly that it created a lot more questions than answers. I would suggest if you have any employee who has requested FFCRA leave, go directly to the DOL website that provides the guidelines, because they are updated frequently. And they're really good about giving the date that an FAQ was added. So if you've checked it in June, and you go back, they aren't just adding questions willy-nilly. You can go back and actually see the new ones. A religious accommodation, again, these are required under Title VII, and they're not necessarily required. If the employee has sincerely held religious beliefs under Title VII, then there is an expectation that the employer will provide the accommodation, and that might be an alternate method of screening. But also the 11th Circuit, which is where Alabama sits, had a recent decision where the court held that the employer's business involves the protection of lives. It was an actual hospital. And the court said they were reluctant to restructure its employment practices. That case was where an employee wanted to be able to be off on a Saturday to attend a religious service, but that left a certain department essentially unmanned. And so the court said, you know what, we're not going to step in here and change the employment practices when you are a hospital where lives are at stake here. So if you have any question about a religious accommodation, I would reach out to your labor and employment attorney or whatever other resource that you use for those decisions, because they can get kind of tricky. Accommodations based on age, those aren't necessarily required, but that is a situation where you can provide an accommodation to an age group that might treat others in a different age group less favorably, but it would be okay. So if you have that request, you can't just immediately say no. And I'm going to skip over to accommodations based on pregnancy. Keep in mind, pregnancy in and of itself is not a disability. So you can't treat a pregnant employee as disabled, but there may be conditions related to that pregnancy that have created a disability under the ADA. So that's the interactive process of determining what's necessary. Harassment, there are all new types of harassment, typically within the workplace. And right now it's showing itself to be more because of this hybrid work environment. Just remember that anytime there is a claim of harassment to anyone in a management position, that claim needs to be investigated. Don't take anything lightly, treat it seriously. So the last few slides, this slide number 32, which is harassment prevention, is going to be very helpful for you, steps that you can take to make sure that harassment doesn't take place among your employees. And then also slides 33 and 34, I believe, are going to be step actions you can take now. And those are going to perfectly coincide with the CDC regulations and EEOC guidelines. And then best practices for updating your policies. If you'll remember, at the very beginning, I talked about how the EEOC had suggested that organizations update their policies custom to your workplace, custom to your industry. And so this is just a good roadmap for you to follow if you're going to update policies so that they address the COVID-19 situation, whether it be an infectious disease policy specific to your employees, or it be an attendance policy or a remote work policy. Again, documentation, this is specific to updating your policies and the way to document that the policy has been updated. And here are some resources for you. Should you have situations in your workplace that you need to deal with, these are all great resources and they are updated as information becomes available. It's not just static reference material. So I would encourage you to look at those things if needed. And lastly, I want to thank you all. It's been a privilege and an honor to be with you today. I hope you have a wonderful conference. And I just thank you for letting me do this. Again, if you have any questions, you're welcome to email me, rharper@lionshr.com. And I hope you have a wonderful day. Thank you.